We were the only other ballot initiative committee formed in January of 2008. We moved out to California essentially to help raise money to get Prop 8 on the ballot. We are not formal parties to this litigation. Protect Marriage took over, and they are the litigants in the case. We are helping to raise money through NAM's Legal Defense Fund for the case. We filed an amicus brief at the request of the lawyers in this case, and we'll do anything we're asked to help it, because this is the future of marriage in the whole United States. I thought Chuck Cooper did a fabulous job under difficult circumstances. I think you could never tell for sure from a judge's comments, but I think the whole way this trial has been conducted and the questions of Judge Walker today made me pretty convinced that he's going to find a way to overrule Prop 8. I hope I'm wrong, and we'll find out. Ted Olson, I think, did a very competent job, but in spite of the wild praise that David Boies threw upon him, I thought it was somewhat workmanlike. Maybe it's just that these arguments have been well developed, and so I didn't hear anything that I hadn't heard before from Ted Olson. I just think that Judge Walker clearly telegraphed, first of all, an over-reliance on the idea that the rational basis test implies that you have social science experts. I mean, I don't know how much social science an ordinary voter has to have to say, well, it makes sense that marriage is the union of husband and wife because these unions, create new life and connect those children to a mother and father, and this is important and socially useful, and same-sex couples just don't fit that definition. So I think there was a big press on the part of certainly Ted Olson and somewhat by Judge Walker to try to narrow the scope of rationality to what an expert witness testifies under oath. I don't know how you can quite do democracy under those circumstances. I also think at one point, and I don't have the quote with me, Chuck Cooper was talking about, that to find a new fundamental right, this is about the due process rather than the equal protection grounds, it has to be deeply rooted in our history and traditions. And Judge Walker broke in to say, well, the right to marry is deeply rooted in our history and traditions. And for me, that was a pretty telling moment, because most courts, even in liberal places like New Jersey, have really rejected the idea that there's a fundamental right to same-sex marriage because it's so obviously not deeply rooted in our history and traditions. So that Judge Walker responded in that way was, to me, a pretty powerful clue about the way he was thinking. I also think that I also wonder about the emphasis that Judge Walker placed on the marriage city clerks and how they identify gender, and that was interesting to me because I was not something emphasized by either the plaintiffs or the defense, so it seemed to be coming from the judge and perhaps preparing the ground for a ruling against Prop 8 as gender discrimination. Another argument that has not fared well in the courts since Hawaii originally accepted this argument back in the mid-90s, because it's so obvious that that making marriage a union of husband and wife is not intended to favor or disfavor any one gender. This really is a case, if there is a case, about whether this is orientation discrimination. I think the gender discrimination is hard to take seriously as anything more than a theoretical argument.